The next case to come before us this morning is in re BD, CD, and ND. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you let me know anytime you want to reserve for rebuttal when you get started, I can feed the clock. You can also feed the clock for yourself up there on the screen. But I can let you know if we're getting close to your reserved time if you choose to reserve any. Please don't use the actual names of any minors or victims. I'm sure you're aware, but we make this advisement each time as we do post the oral argument on the court's YouTube channel. We have read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. David Belfiello for the appellant. Would I reserve 3 minutes for rebuttal?
Certainly.
Okay. May it please the court. 2019, Jessica Dix and her children lived with an abusive husband in a home which Summit County Children's Services found, quote, was marginal but not deplorable. The agency became involved initially because her 6-year-old was not enrolled in school. She had some distrust of the system that repeatedly failed her, particularly when she went to the battered women's shelter seeking safety, only to be attacked and brutally beaten there inside the battered women's shelter. 2.5 years later, Ms. Dix has separated from her abuser. She has a new appropriate home and adequate income. Nonetheless, the juvenile court kept her children from her based almost entirely on her failure to complete her case plan, something that both case law and statute indicate is not dispositive. Ms. Dix therefore appeals for her children to be returned to their mother's care. If there are no questions from the bench, I would make some points about the first assignment of error having to do with manifest weight. The trial court's decision to, the main reason cited for denial of the mother's motion for legal custody, probably the most important reason is stated has to do with not completing the case plan, which involved mainly treatment for substance use, that she was continuing to test positive for marijuana as of last time she actually did a test, and for alleged mental health issues, or undiagnosed mental health issues, I should say. And of course, failure to complete a case plan is not dispositive, and also point out, probably more importantly, the case plan reads that the mental health conditions, the substance conditions, really they have nothing to do with the reasons that the agency became involved. There's no proof that they caused her to keep the child from being enrolled in kindergarten. They have no proof that they had anything to do with the condition of the home, and then those are conditions that are remedied 2 years later. There's no, and yet there is case law that requires a causative connection between both the mental health and the health issue and substance abuse, and call the court's attention in particular to in Reed DA, that's a Ohio Supreme Court case that held that it was error to take a child based solely on parents' mental retardation without any proof that caused them to be unfit parents. As far as any allegation that she doesn't have an adequate home, she has, and I think every party conceded this, she has a new home now, not the one that the case was removed, and as will be discussed more in detail under assignment error 2, it was the state's failure in case planning which had caused her new home to not be seen by the state. And so as things were at the date of trial, it was her uncontradicted testimony that her new home is appropriate, and even though it's preponderance of evidence, the state does have the burden to prove that her home was not adequate. The state failed to consider any mitigating evidence. If you read the judgment below, you would come away believing that Ms. Dix had simply stopped visiting her children abruptly. You would not know that she had been beaten so badly, she had these injuries to her face, that I believe it was the CASA agreed that her children should not see her in that state.
Was there some testimony about the availability or availability of telephone contact during that period of time? I know she was going through some hospital procedures which may have, for a time, caused her, maybe couldn't pick up the phone, but what about the remaining months?
Yes, Your Honor, there was, I'm not sure if there was direct testimony in the availability of phone calls. There was testimony to the effect that she did not attempt to make telephone calls, and I believe there was testimony that earlier in the proceedings she was at times making telephone calls. I think really the issue that goes to the second assignment of error was that she and the caseworker lost touch, and I don't think either side, made perfect effort there, but I think that, but with this extraordinary situation that she was beaten up inside the battered women's shelter, she was hospitalized for more than a week, that, some effort, more than a phone call a month, would have been in order, although, there is, of course, not, the state will point out that reasonable efforts did not mean all available efforts. The state has some tools to find people's addresses when they want to find people. The state has, the caseworker testified that she had 8 different phone numbers for Ms. Dix, indicating, as many people do, that she was someone who changed phone numbers frequently. It should not have been surprising for the case that for the caseworker that an old phone number was no longer correct. I think somewhat more effort, maybe an attempt to visit her in the hospital to assure her that, that the department was still available to her, that they wanted to maintain that relationship, get her back on the track of the case plan as soon as they could. Something more, and email, well, I suppose you don't know if it's on the record, but there is an email address for Ms. Dix. But something more to attempt to maintain that contact would have been in order to help Ms. Dix get back in touch with both the children and with Children's Services to get working her case plan, and that would have enabled them to evaluate the new home and get updated proof of income. There was proof of income provided to Summit County Children's Services. So, I would point out this is not a case where somebody didn't cooperate at all with the agency, didn't work on their case plan at all. Her progress before her hospitalization was, not satisfactory. Her cooperation was, probably not at the level we'd like to see, but it was not zero. She attended some treatment appointments. She was discharged at one point, re-engaged of her own initiative. She would get back to the caseworker, she would get back to the CASA, maybe not as promptly as some would like, but that there was some cooperation beforehand, and then there's no contact after the hospitalization up until the day of trial. So, I think, I don't think it would have been futile to make a little more effort to get back in contact with Ms. Dix. And I think it may have been productive, and the situation warranted some extra effort. As to the third assignment of error, the state replied that the agency was not required to, quote, favor relatives on mom's side, which of course is true, but the new statutes absolutely say that when a child is in temporary custody of the agency is required to search for a kinship placement. It lists one circumstance in section 2151.4118, I believe, in which the court may determine that an effort is no longer needed. That section does not apply here, that finding was not made. The plain reading is that intensive efforts to search for kinship placement were required to be continued here, and were obviously not done. You know, the caseworker pointed to some, or the agency points to some reasons that suggested kinship placements on the mother's side may have been unsatisfactory, and you know, I mean, they may have been deemed unsatisfactory in the end, but there's, you know, at least some decent chance that they would not have. The agency, as part of intensive efforts, would have some obligation to actually make that evaluation. They dismiss the grandmother on the basis that she was homeless 2 years ago. She may have, you know, that's obviously not an indication that she didn't have an appropriate home at this point. They dismissed the mother's adult son on the basis that the mother reported he had developmental delays, but also reported that such delays did not affect the way he lived, which having developmental delays is not necessarily disqualifying. They should have done some kind of assessment as to his actual ability, and they refer again to the case law I've already referred to in re-DA and re-Lexis K, that developmental delays are not per se disqualifying. As to the fourth assignment of error, I would just say that it seems that, that there's all witnesses to the encounter agree that this is to whatever altercation took place at the visitation center. Everybody agrees that Brooke Moore, who is the custodian of the oldest child, pushed Ms. Dix. That there's allegations that there was some provocation.
And Council, just wanted to let you know you've reached your 3 minutes of rebuttal time. You may continue or reserve as you feel.
Okay, I'll continue very briefly. So, there was some, there was an allegation of provocation. Ms. Dix disputes it. The only thing that's agreed on by all witnesses is this assault by Ms. Moore did take place in Ms. Dix, so I would say that it's Ms. Moore who's the obstacle. If there are no questions, I reserve the remainder of the time for rebuttal.
Seeing none, thank you. We'll have just over 2.5 minutes.
Thank you.
Good morning, Your Honors. May it please the Court, I'm Jacqueline Atcorda on behalf of Summit County Children's Services, the appellee in this matter, to urge this court to affirm the judgment of the juvenile court. Basically because the juvenile court did not abuse its discretion in this case when it granted legal custody of these children to 2 different relatives, or when it ordered paid visitation by mother. Now, granted, with the case of legal custody versus permanent custody, there really is no statutory test to determine whether a court has abused its discretion in making such a custody award. However, this court looks at the children, what is in the children's best interest, and for that, it does take guidance from Revised Code 2151-414D. And so it looks at the children's interactions and their interrelationships, looks at the children's wishes, and if they're, as in the case of 2 of these children, too young to express their wishes, looks at the opinion of the children's guardian ad litem, looks at the custodial history of the children and their need for a legally secure placement. But those are non-exclusive factors. The court is free to look at any other evidence it finds relevant. Now, talking about what is relevant to this case is, first of all, the reason why the children were removed from this household in the first place. And it is not solely because mother did not enroll her oldest daughter, the 6-year-old, in kindergarten. It's the Children's Services was called out to check on the welfare of that child because she had not been in school. What they found then was that mother's behavior and father's behavior as well was chaotic and hostile and indicative of drug use, which is a danger to the children, and that's what Children's Services believed was occurring. In addition, the home was marginal, or described as being marginal. There was little food, there was a large puddle in the basement from a backed up drain that mother said that she had attempted to get the landlord to fix, but when Children's Services offered to intervene to fix that, she refused, and she simultaneously reported that there were drug users who were also living with her in the home and who were leaving used needles in the basement. So this was not just a case where it's just a question of, is this child being enrolled in school, but it was a totality of the circumstances that the agency saw at the time, and that gave rise to the questions about mother's mental health and also her drug use. In addition, I would mention that at that time, mother also reported to Children's Services that she was suffering from untreated bipolar disorder. So that factored into a suggestion that her mental health might have been endangering the children as well. So that's why these children were removed. And that's why the case plan that was developed for mother sought to compel her to address her untreated mental health issues and her substance abuse issues, as well as finding safe and appropriate housing, so meeting the children's basic needs. And I would remind the court that even though case plan compliance is not dispositive, either for or against, a case plan does become an order of the court, and that is what has happened in this case. It was approved by the court as a court order. So mother was expected by the juvenile court to comply with these case plan goals. And when this came up for a hearing, the trial court had good reason not to believe mother's testimony concerning her case plan compliance or the efforts that she had made toward complying with her case plan goals. For example, regarding the house that she said at the hearing she was purchasing through a land contract agreement, she was unable to provide any kind of copy of that land contract agreement, and there was no record in the hands of the agency or the guardian ad litem that she had attempted to inform Children's Services or get in touch with them where they could have gone out and viewed that home. There was also the changes of cell phone by mother. She had testified that she had changed cell phones in the period of time since that attack that she had suffered at the battered women's shelter. So she had not informed CSB of the new number, apparently. There were no pay stubs from mother for the job that she said that she had held since October of 2020, a full year before the hearing. And despite apparently having the means to obtain housing because of that job, she testified she went to the battered women's shelter to obtain help in obtaining housing. So it raises a question, if she had the income that might have supplied her with the ability to obtain housing, why was she going to the battered women's shelter to get assistance in that? In addition, however, all of the counselors who reported to Children's Services concerning mother's progress in meeting her goals of not only being assessed for drug abuse or her mental health, but also following through with treatment, all of them reported to both the agency and to the guardian ad litem that mother needed continuing counseling to address both issues. Meanwhile, mother said that she didn't need any. So she was saying, everything is fine, I'm okay, I don't need counseling, but the professionals who were treating her or who were supposed to treat her said she absolutely did. Now, let's talk a little bit about what cannot be attributed to the battered women's shelter attack. First of all, mother's consistent failure to be consistent with her visitation prior to the battered women's shelter attack. And Judge Hensel, that gets to your question, was that, yes, she failed before that to consistently visit with these children, to the point where she was twice removed from the visitation schedule at the Family Interaction Center for missing visitations 3 times consecutively in a row, and she did it twice. Then she had actually asked for her telephone calls with Deanne, the oldest of the 3 children involved in this case, to be limited to 1 day per week. And then she was unavailable on that day per week. So she didn't even comply with the telephone schedule that she had asked for. And that was before the attack at the battered women's shelter. And that is, and also, getting to another question, I think it was from Judge Hensel, about whether she attempted to contact the children by telephone after the battered women's shelter attack, at a time when reasonably no person would want to be seen in a battered condition, and that's understandable, but did she try to contact the children by phone? The record indicates that the answer is no. So even when she could have been in touch with her children by telephone, so they wouldn't have to be exposed to the visual of her battered condition, she still didn't do it. In the meantime, again, there's no record from either the agency or the guardian ad litem that she attempted to call them, even though she testified that she did. So it's a matter of who do you believe, and that's a credibility determination that gets made by the court, by the trial court. So, but as a result, I do want to talk about what's going on as a result of the battered women's shelter attack. Mother testified that she has memory issues now. She also will need future surgery, and there's no indication on how many surgeries she's going to require, how long the recovery from that would be, and there was nothing for the trial court to consider about whether mother could even take care of the children while she was recuperating from those surgeries. Now, getting to the reasonable efforts determination, I would remind the court that even though this isn't necessarily dispositive of the reasonable efforts determination at legal custody, but the court had found that the agency had made reasonable efforts to reunite this family twice, first in January of 2020 and again in March of 2021. But pursuant to this court's decision in Inri KR from 2021, some of the things that an agency does that would be reasonable efforts to reunite a family are, for instance, making a case plan, reviewing that with the parents, coordinating visitations for the parents, and investigating kinship placements. All of those things were done in this case. The case plan objectives were reviewed repeatedly with mother, even though she testified she doesn't remember that. The agency's caseworker testified that she texted, called, tried visiting mother monthly between the time of the battered women's shelter attack and the October hearing. The case plan was in effect 2.5 years before the hearing. Now, Herculean efforts by the agency are not required to be reasonable, and also clairvoyance on behalf of the agency or on the part of the agency to divine where mother may be and where what her phone number may be currently is also not required. All that's required are reasonable efforts, and the agency asserts or submits that the trial court did not abuse its discretion in finding reasonable efforts have been made. Now, concerning kinship placements, the current statutes which went into effect only shortly before the hearing in this place only address situations where kinship placements have not been found. An agency is not required to make intensive efforts to effect kinship placements where kinship placements have already been made. I mean, by the plain language of the statute, of the statutes, it's supposed to address situations where children are being placed in foster homes where they are not related to the foster parents. In this case, all of these children are in kinship placements and have been in kinship placements, especially Deanne, who's been in the same kinship placement for quite some time. Mother's difficulty is that mother doesn't like the kinship placements that were found because she does have a conflict with Deanne's cousin who is her placement. Now, discussing mother's proposed placements, she proposed a family in Youngstown that turned out to have unacceptable criminal histories and then dropped out of contact with the agency when further inquiries were being made, and may have even left town. Maternal grandmother who had the care of some of mother's older children was found to have neglected them and then became homeless. So the agency had that knowledge in front of it about whether maternal grandmother could be reliable or not. As far as the adult son, at a minimum, concerning his developmental delays, those were known to the agency because he had been in the agency's care prior to him turning 18. So he was not an unknown quantity to the agency. They were well aware of whether he was capable of caring for other children. And in addition, he also did not cooperate with the agency in his own case. So that at a minimum is enough to keep him from being considered to be an acceptable placement. And I understand that I have less than 2 minutes. I will very quickly touch on visitation and why the court did not abuse its discretion when it determined that paid visitation was proper. Again, it has to be based on the totality of the circumstances as it relates to the best interests of the children. And this court has made clear in INRI LS from 2018, when there is no objection to a visitation determination or visitation decision, that issue is waived for appeal. And that's what happened here. Mother made no objection to that. It has not developed a plain error argument. So that issue is waived. However, the record does support paid visitation for mother when, as we've been discussing, she created her own visitation problems when she had free visitation from the agency, and there's also no evidence that mother cannot afford paid visitation. After all, she says she's been employed at the same place since October 2020. But again, she created the problems of visitation. She's the one who participated in the affray that caused the Deanne's caregiver to push her away. So it only makes sense, reasonably, logically, that some kind of neutral, safe place should be used for visitation. Whether that's paid or not was up to the court, and it reasonably made that determination that it would. Unless the court has questions, I know I am 2 seconds, and I would urge this court to affirm.
I have a quick question on the visitation issue. Was it, based on your review of the record, is it the safety of the children or the safety of the children's legal custodian about which the court was concerned?
Well, there wasn't any indication that the children were in any danger from mother during visitations. So it kind of by lack of a statement, it follows that it would have been the custodian's safety.
Thank you.
Thank you.
Thank you, Your Honor. And to the last question, I don't believe there was any reasoning of the record has been not in the judgment as far as paid visitation. mean, I would point out real briefly, obviously, that the problems in the past home are not the current home. No one's alleging that she lives in the current home. This erratic and rude and hostile, I believe the word used was, mainly not wanting to cooperate with the caseworker, although the Sticks did cooperate once a court order was given. She had no obligation to allow the caseworker in her home before a court order was given. Once an order of April 3rd, 2019 was given, she immediately did allow the caseworker in her home, although she was still allegedly rude. Bipolar disorder was something she stated she had, but was never diagnosed. That seems to be a little bit of a pattern with her, that she kind of speculates in these disorders. The case plan was indeed a court order. Someone who doesn't comply with the case plan can be held in contempt. They're not punished by having their children taken.
Counsel, in your research on this case, did you find any cases where, through appellate case records, where the parent was held in contempt for failure to follow a case plan?
I did not find any cases where that happened. I know there is a statute that says they can. I don't have the number with me right now.
No, you cited the statute, I just want, thank you.
But in any case, if there's a need to punish, that's the proper remedy. We don't take children as for failure to follow a court order. As far as any, memory problems of the mother that she says she can mitigate them with Post-its, there's no evidence to the contrary, and it seemed like mild things like forgetting where the car keys are. I think we've all gotten home and, forgotten to run an errand. And there was one visit at conceitedly after mother's hospitalization, the caseworker made one attempt to visit her previous address. I think this reasonable is always context dependent. I think this situation made reasonable efforts, not clairvoyant, but somewhat elevated than they'd be in other circumstances. The amount of time. Thank you, Your Honors.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website, which you can access through the 9th District website. We are now adjourned.